separation between myself and the company would shield me from an economic event. But now let's look at another situation. In this other situation, I am building a house and I elect to do something that violates the tenets of my license. I elect to take steel out of the footing and put it somewhere else and then pour the concrete with no steel in it. And down the road, as a result, there's an economic consequence because of this decision to violate the licensing law. Since what I did violated a rule that I was supposed to follow while I had this license, then an economic consequence that results from that, I will not be able to shield myself from, no matter how many layers of organization I choose to put there. If I am the primary, and I'm involved in a situation where I've violated a tenet of the license, then I can be held responsible, and there will be no separation or shield as the corporation might otherwise offer. And in fact, this is true of any situation where someone is licensed in any of the various professional categories. Looking once again at the primary qualifying agent, you indicate, or it indicates here the numbers. Number one, it's the license holder, can be more than one individual, is responsible for both finance and field activities, can never separate from field activities. The individual can qualify one company at will, but must petition the board to qualify additional companies. Now, in theory, you can qualify as many companies as you want, but you have to appear before the board and convince them that you should be allowed to do this. Now, what are they going to be looking for? Number one, is there a legitimate business reason? And number two is more important, can you in a realistic way be expected to personally visit and oversee the operation? So if you're living in Miami and you're trying to qualify a company in Tallahassee, that would raise a legitimate concern as to how you would actually be overseeing the field, since you are responsible for the field. The next box underneath that is the secondary qualifying agent. Now, this is an optional situation. And in this situation, you have decided as the primary that you want individuals with licenses to be responsible for certain specific geographic areas. Such people, if they come forward and agree, can be appointed as secondary qualifying agents, and they then become responsible in the field only for areas in the field that they have elected to be responsible for. For example, if a big corporation were to say, we want a secondary qualifying agent to run the Dade County operation, then they would be looking for a license holder that would be willing to be responsible for everything in the field that happens in Dade County. Now, the organization still needs a primary, and that primary will still be responsible for what happens in Dade County, in the field. However, the secondary would now also be responsible. Now, other issues about the secondary are this. A primary qualifying agent, if I'm a primary qualifying agent for a company, and I choose to leave that company, and by the way, when I say leave the company or terminate my primary status, what I'm talking about is sending a formal notice to the Construction Industry Licensing Board. Physically disappearing is not what's being described here. I write a formal letter of resignation withdrawing my license from the company to the board. Now, if that happens, the company has 60 days to replace me, and during that 60-day period of time, I am still on the hook for anything that company does. If there's no FRO, I'm on the hook both in the field and at the bank. If there is an FRO, a financially responsible officer, I'm on the hook for what happens in the field. But I'm still on the hook for those 60 days. Now, this company has 60 days to get a new qualifier. And if they don't get a new qualifier, they cannot continue in operations. Now, another possibility is that I might die. If I die, the contracting company has 30 days from my death to notify the state that I've died. And then, because they're still in that 60-day period where they have to get a new qualifier, they have another 30 days to do one of two things. Either A, replace me with a new qualifier, or B, write the state and say, look, we are closing the business down, but we have contracts in progress and we need to complete them. And tell the board of an individual who's responsible in your company, hey, we think this person who is the vice president is a responsible person. He's not licensed or she's not licensed, but they could complete the work. Such a petition, if approved by the board, would allow that company to wind operations down. They could complete contracts that were in progress, and the definition of such a thing is a contract in which you were the lowest bidder. So in other words, you might not actually have started the work yet, and yet you could be in the middle of a contract, and you would be allowed to finish the contract if the board approved without getting a new qualifier by appointing someone that the board approved of that didn't have a license that was trying to wind the company down. under the secondary qualifying agent. Number one was that this is a formal appointment. You can have several of them. Number two is that he or she accepts responsibilities for designated field activities, and they have to have a contractor's license. Number three is they have no financial responsibility. Now, don't confuse this with if they're cheating or stealing, they have a financial responsibility. But in the course of normal business operations, or if others are cheating and stealing, then they do not directly have responsibility for the financial arrangements. Number four is that the primary is also responsible for field activities. And number five is, if the primary leaves, as I outlined a moment ago, in the absence of other information that's contrary, any secondary in the organization automatically becomes the new primary. And so one gets a promotion without necessarily even being aware of it, and suddenly can find oneself in the position of being responsible for everything. Now, turn back to the exhibit, that is to say, the outline. And you'll notice that we covered some of the topics under 489. And we can pick up on item number 9, which we also already covered, which is the CILB. And topic number 10 is continuing education, and contractors must have 14 hours every 2 years. Topic number 11 speaks a little about workers' comp and says that contractors must have workers' comp. There's an entire chapter devoted to workers' comp that we'll deal with separately. Realize that in construction, if you have even one employee, you must have workers' comp, period. Next sentence. However, there is an allowable exemption for up to 3 corporate officers. So, I, being Robert Tannenbaum, qualifying agent for Tannenbaum Construction, Inc., could elect to be exempt from workers' compensation. And if I chose to be elect, I still would be in compliance with the law. There may be other problems with that decision, but I nevertheless could comply with the law by being exempt because there is an allowable exemption. Otherwise, having a workers' comp policy is required. Topic number 12, we talked about a little bit. If there is a loss of a qualifier, if it's a death, the company must report within 30 days and do something within a total of 60. And what they must do is either replace that qualifier or petition the board to wind operations down. In a normal situation where the qualifier doesn't die, the company has 60 days to get a new one. Now, there are several rules about dealing with residential construction in this statute. And one of these rules is item number 13 that has to do with advance deposits being received. And what this says is that if you take more than 10% or 10% or more up front from a residential customer, then a series of time frames click in on you. And you must apply for permits within a period of time. And then once the permits are issued, you must start the work within a period of time. And then once you've started the work, you cannot stop the work for more than 90 days, a period of time. And each of these timetables is outlined in this section, and you need to be aware of how this would work. Topic number 14 are a variety of prohibitions, things that we're not allowed to do. And most of these make common sense, but some of them are a little bit of hair splitting. And as you look through them, you may get the idea that some of them are hair splitting. Nevertheless, these are the rules and these are the items that we are required not to do. Topic 15 we have already dealt with, which is contracts with unlicensed people are unenforceable. Topic 16 has to do with the maximum fine. Now, we talked about the difference between the statute and board rules, and sometimes it's difficult to determine up front whether a bit of information is going to be in the statute or it's going to be in the board rules. But in general, the statute outlines the broad framework, and now this board is created to implement the statute, and it starts creating rules to implement this statute. And these rules will tend to be more specific. So the licensing law will set the parameters, and the board rules will interpret the specifics. So if we were looking for the maximum fine, that would be in the statute. And the maximum fine is $5,000, but that fine can be levied against both an individual as a qualifier and a company. So in theory, a one-man band who is both the qualifier and the company could face a $10,000 maximum fine. $5,000 for himself personally, and then $5,000 for the company. But if we were talking about specific penalties, such as what happens if I don't use my contractor's license number on a business card or on a contract, or what happens if I aid and abet an unlicensed person, those specific penalties will be in the board rules. Topic number 17 is one that, for reality's sake, you ought to review. These are specific definitions for financial mismanagement. And fortunately or unfortunately, you could be very good-willed and kind-hearted and not understand these regulations here and wind up getting into hot water, not from your intention, but because you did not understand what financial mismanagement meant within the context of this statute. On the other side of the fence, unfortunately, you could be quite a scoundrel and understand the hair-splitting of these definitions and possibly avoid problems in getting the consequences of what you are doing. We certainly don't recommend that point of view. Nevertheless, it's important that you understand what financial mismanagement is, and so you can keep yourself out of trouble and do the right thing. Another item here is arbitration, number 18. We will talk more about arbitration in the section dealing with the AIA documents, but you will hear increasingly about mediation and arbitration, and in the statute, arbitration is allowed for in the event of disputes. You do need to understand what the difference is between these two processes, and the difference has to do with the role of the process. Most people will say the difference is in that one is binding and one is not, but whether or not either of them are binding depend upon how you get there. The processes themselves, however, go like this. In mediation, the goal of the mediation is to get the parties to come to an agreement. So the mediator is supposed to act something like a bowl of Jell-O. The mediator is not allowed to make decisions. The mediator is not allowed to impose solutions. The mediator is supposed to massage, is supposed to invite, is supposed to explore, is supposed to allow the parties to vent, is supposed to get the parties to come to a meeting of the minds on their own. And that's the process of mediation. Arbitration, on the other hand, is different. In arbitration, the arbitrator listens to one side, then listens to the other side, and then like a Solomon raises the sword to chop the baby in half and watches who flinches, and makes a decision as to which way the arbitrator is going to go. In that sense, the arbitrator imposes a decision on the situation. The point that's in the statute is that if you then submit to arbitration immediately in the event of a dispute, you can often avoid any of the other consequences in the process. And if the arbitration comes out successfully, then the problems are eliminated. Topic 19 is a permit bond, and you should be aware that that's one type of bond that municipalities can require. That means that although you have a license, you might still need a bond in order to pull a permit. Item 21 talks about prohibited acts, unlicensed principals. The word principal here means someone who is involved in the corporate structure, an owner. And if they're unlicensed, it means they don't have a contractor's license. And the point of all this is that they are not allowed to do anything that the license holder is not allowed to do. And there are consequences for unlicensed principals, although it is usually the qualifiers that wind up getting into hot water. The final topic here has to do with something that also pertains to residential construction, and that is the existence of a recovery fund. The recovery fund is set up, and a portion of every building permit, a couple of pennies go to this fund, and it's set up for the following situation. If a consumer has a problem with a contractor. Now, we're not talking about an air conditioning contractor fighting with a general contractor. We're talking with a consumer having a problem with a residential contractor. And the consumer has done everything they're supposed to do, including getting a judgment against the contractor. But the consumer is not able to get any money out of the contractor. Then the consumer can take that case after they got the judgment, as long as it's within 2 years, and give it to the board, bring it to the board. And if the board investigates and agrees, then the board will award that consumer a dollar amount. Now, there are dollar limits to this, and if you find yourself in an unfortunate situation like this, you can imagine that before you'd ever be able to contract again, you'd have to pay the board back what they paid the consumer. These are the things that you'll be asked about as far as the statute is concerned. You can expect to get 2 or 3 questions from the statute. The last section of your module is section 5, board board rules. And so now we get into some of the specifically particular items that the board has ruled on. And again, you're going to have to recognize that there are 3 different tables of contents here, and that generally speaking, the board rules are more specific than the broader outlines of the statute. On your outline, the first item is the probable cause panel. And this is an investigatory procedure. If a complaint is filed against a contractor, a probable cause panel is organized to determine whether there's sufficient grounds to further investigate the situation. And this is described in the appropriate reference off to your right on the outline. And once again, you need to go through your book and mark the appropriate sections. Keep in mind, as we've said before, you cannot write in your books, but you are allowed to underline and highlight information. Number 2 is the procedure for qualifying more than one company. You can do so, but you must appear before the board and explain why you should be permitted to. Numbers 3 and 4 are very frequently asked about. These are 2 tables in these rules that indicate the minimum requirements for different categories of licensure. We must have a minimum of liability insurance, $300,000 and $50,000, and we must have a minimum net worth of $10,000. And you'll want to make sure you can get back to these tables should you need to. Item number 5 sometimes confuses people. In the statute, there is a section that says that if you change information pertaining to your status as a company or your application, you have 45 days to notify the state. In this section on change of address, it says that if you have changes of information, such as a change of address, you have 30 days to notify the state. In the first case, the 45 days, they're talking about information that changes the character of the business relationship, changes in ownership, and that sort of thing. Other routine informational changes is 30 days, and they often ask about this time period of change. Topic number 6 deals with replacing a qualifying agent, and the possibility does exist to get that temporary certificate that we spoke of earlier. The topic number 7 is one that you want to spend a little time looking at. Now, we actually are going to take this topic apart in Module 10. But topic number 7 is telling you the content of your examination. And it's taking various topics and showing you what percentage of the questions are probably going to come from this topic. Now, as you get more familiar with what's really in the books, you'll be able to see what those topics are and get an immediate sense of where that information might be. And in Module 10, we will describe this to you and review where these different questions are coming from so that you can focus on those areas that you need to and go on with this process successfully. Number 8 is asked about quite frequently, and that's disciplinary guidelines and penalty ranges. If you haven't heard us say already, you will hear us several times say that in this type of an exam, the literal is of senior importance to the accurate. The literal is more important than the accurate. And what is meant by that is that if the book expressly says something, then even if you know better than the book, or others know better than the book, or in fact the book might be mistaken, you still need to answer what the book says. And so you look for the literal interpretations. There are specific penalties outlined here for specific things, such as aiding and abetting an unlicensed person. Maybe it's the first time, maybe it's the second time. Maybe it's the first time with no serious consequence. And each one of these particular conditions are particularized in this section of the board rules, and they tell you what the penalty is. So if you're asked on the exam, what is the penalty for, and they tell you a condition, you want to find the exact circumstance that describes literally what that penalty is. You don't want to try and invent or calculate what that penalty might be. So that's how you have to look at these particular items. Topic number 9 features some specific penalties that have historically been looked at: obtaining licenses fraudulently, assisting unlicensed persons, operating beyond the scope of the license, a license number missing from an appropriate document, contracting with an inactive license. All of these items are things that have been asked about. And so there you have this Module 2. Hopefully we've been able to give you some ideas of organizing and starting a business, how the different formations of business affect outcomes in business circumstances. We've then taken a look at the Circular E, the Employer's Tax Guide. We've looked at Chapter 489, the licensing law. We've looked also at the board rules, and you have some work to do here. You now should take some time and take the exam that's at the end of this module and bring any questions that you have to your next workshop. And as always, I'll see you at the craft.